Good afternoon or good morning, depending upon where you are, and welcome to our webinar on pre-writing exams. And so this webinar is a part of a series that we've been doing as tips for law students. And this one is just about pre-writing your final exams, which has to do with preparing for your final exams. I am Professor Brittany Raposa. I am a professor at Roger Williams University School of Law, and I will be hosting this quick tip webinar. And so let's get started. So the first thing, of course, is what is pre-writing and what does pre-writing your exams mean? And so essentially it means setting up what a written response would look like before you actually take your exam. And so it involves organizing the law. So if you had a question on a particular subject or topic, how would you organize that particular topic when you're writing it out? How would you write your rule statements? So it involves actually coming up with a document where you pre-write and prepare your rule statements ahead of time. It allows you to envision, like I said, the organization and structure of an entire essay prompt in a subject. And it allows you to parse out tested topics. And so it helps with issue spotting. So if you are in a criminal law class and you are dealing with murder, what are the different types of issues you may have to address when answering a question about murder? Or if you're in a torts question and you're talking about negligence, what are all of the possible issues that could potentially come up in a negligence essay question? And how would you organize those issues, and what would be the rule statements you use for those issues? So it allows you to not only organize the law, but pre-write and prepare your rule statements, envision the organization and structure of your essay, and to parse out tested topics and issues that you might have to address. So we're going to talk about this in 3 steps. So step 1, 2, and 3. So step 1 involves breaking down the topics you've covered in class. So the topics you've covered in class become potential issues on your exam. So how do you know what the topics are that you've covered in class, apart from, of course, being in a semester the entire time, learning a bunch of different topics? I think the best part to start with is your course syllabus. How does your course syllabus break down the topics? Start there, and those are the overall topics that you will be learning. Then it gets a little bit more granular, and you can go into your casebook and your class notes and think, what are the subtopics I've learned in each of those subjects? So for example, if we're in a torts class and we're dealing with negligence, there are many different subtopics that you've learned in the big topic of negligence. We've got duty, breach, causation, and damages. Then you even have more subtopics that you could have learned in those. If we take duty, for example, we could have a potential issue of whether a duty existed in the first place, whether an affirmative duty existed, if the reasonable standard of care was present, if we're dealing with landowner liability. So all then the different sub-issues you would parse out. And of course, I'm going to show you an example of how to do this. So after you've broken down all of the topics you've covered in class and all of the subtopics you've covered, you want to list those out. Make a list of them, and you can even do so in outline format. This gives you your initial skeletal template to pre-write your exams. So step 2 would be to structure your potential exam essay. For each of those topics, how are you going to be tested? Which issues, like we talked about, could come up on the exam? How could you potentially be tested on those topics? How would you break down those issues if you were writing an exam question testing those issues? What would your headings be? How would you break it down even more so in terms of the writing structure of this exam prompt? How would you create your headings to answer a particular question testing negligence, for example? And then what would your overall organization look like? If you're writing a problem on negligence, you probably will have 4 major subheadings: duty, breach, causation, and damages. And then depending upon what you're tested on and what the hypothetical or fact pattern is, what are going to be your potential even further sub-issues, and how would you sparse those out? So finally, step 3, determine your rule statements, and you need to do that so you can pre-write your rules. So for each topic and subtopic that would be an issue or a potential issue that you've addressed on an exam, pre-write them. What would the rule statement be? Remember that you can make this rule statement in a really easy to understand way. If you've got a closed book exam, then you want to pre-write your rule statement in a way that's going to be easy for you to memorize. If you have an open book exam, then you can absolutely use this pre-write as an outline to just copy then what you have already written and prepared into your exam document. And so quickly, when we talk about how to write your rules and how to pre-write your rules, how do you want to write them? You first want to start with your general rule. Then you want to define and get a little bit more specific. What are the pieces of that general rule that need more elaboration or that you need to provide definitions for? And then list any possible exceptions that could potentially come up or be applicable on your exam. So for example, if we are in a contracts essay, right, and we are dealing with contract formation, and I am dealing with an offer, and whether an offer existed, my general rule is going to be that rule for an offer. An offer is a manifestation of willingness to enter into a contract so made as to justify another in understanding that his assent is invited and will conclude it. I might need to define that further, right? Because what is actually needs to be included in an offer? An offer needs to be sufficiently definite and needs to identify any particular terms. Then I might put an exception in my rule. However, an invitation to deal or a question about a particular issue might just be a preliminary negotiation and not actually an offer. So I am thinking about writing my rule statements in that same way for any class or any topic, from general to specific. Write down what the general rule is, define that general rule, and then list any possible exceptions. If you are dealing with a class like torts or even criminal law, where there are a lot of elements, the first thing that you want to do is list out all of the elements. Then you want to define those elements, and then, of course, list any possible exceptions to those elements. So we've talked about 3 steps, right? So we've just talked about step 3, which is actually pre-writing these rules and how to write them. And step 2 was determining that structure and organization of our exam. And that first step that we're doing is that preliminary step that we really need to do, which would be to determine what even are the topics that are potentially going to be tested on my exam and what is my professor potentially going to cover. So let's take a look at an example of how we can do this. And as an example, I am using civil procedure because I think it lends itself well to talking about pre-writing and how we could potentially pre-write an exam. And so say, for example, I'm in a civil procedure class and my 2 big topics that my professor is going to test are subject matter jurisdiction and personal jurisdiction. So I know my professor has told me, or I know a predominant amount of the class in the semester has focused on subject matter jurisdiction and personal jurisdiction. And so I need to be prepared to write an essay on one, or honestly, probably both. And so now I am going to pre-write for those 2 topics. So I'm going to, and that's step 1, right? I've identified my main topics. And then now I'm even still in step 1. And like I told you, it's important to identify your subtopics. What are the potential sub-issues within an overall topic that you might be responsible for knowing? So in subject matter jurisdiction, I'm likely going to be tested on federal question jurisdiction or diversity of citizenship jurisdiction. And so I've determined my overall topic and then my subtopics that I could potentially be tested on. And these subtopics, like I told you, are issues or potential issues. So when I'm looking at a fact pattern that's testing subject matter jurisdiction, I already know that a potential issue I need to look for in the facts is whether federal question jurisdiction is present and or whether diversity of citizenship jurisdiction is also present. And so when I am in step 2 and step 3, right, I am organizing and writing my rule. So when I'm going to write an exam on subject matter jurisdiction, I know organizational wise that I'm going to have an overall heading that says federal question jurisdiction for that analysis. And I'm going to have another overall heading that says diversity of citizenship jurisdiction for that analysis. So that's how I will organize it. Then I will have the general rule for federal question jurisdiction. I'll write it. I will then write any definitions that I need to further define that general rule. And then, if applicable, I will do or write any exceptions. Similarly, for diversity of citizenship jurisdiction, I'll define what the general rule for diversity of citizenship jurisdiction is. I'll provide any further definitions, and then I will list any exceptions. Similarly, my next broad topic is personal jurisdiction. So, what are all of the issues I could potentially discuss in personal jurisdiction? So I know that if I have, and I know this from being in class and potentially doing hypotheticals in class or practice problems in class that we've talked about with my professor. So the first thing that I'm going to address in a personal jurisdiction problem is the long arm statute and whether the long arm statute is satisfied. Then there's the potential issues, right? What are the potential issues that could come up under this broad topic of personal jurisdiction? That's what you want to pull out, right? Those potential subtopics, which then become potential issues that you might have to see in a fact pattern. So a potential problem that can come up in personal jurisdiction is whether traditional basis of jurisdiction exist, whether that's tag jurisdiction being served while you're present within the forum state, whether that's consenting to jurisdiction, or whether that's appearing in court, and then by default indirectly consenting to jurisdiction. So that's something that I want to be on the lookout for and that I can pre-write my rule statements for. So for example, under tag jurisdiction, I will write just what I indicated. A defendant may be subject to the court's personal jurisdiction if they are served while present in the forum state. However, there's an exception to that, which I would also write. Right? So an exception to tag jurisdiction exists if the individual is in the forum state, 1, against their own will, or 2, for another court proceeding in that jurisdiction. So I would write that out, right? Because I'm pre-writing that rule. 1, it's preparing me to look for that issue of tag jurisdiction on an exam. But 2, I've already got my rule statement written if tag jurisdiction is an issue on the exam. So then another issue that could potentially come up on my personal jurisdiction exam is specific jurisdiction. And I know that generally for specific jurisdiction, we need minimum contacts and we need fairness, which is an analysis of the fairness factors. However, remember when you're doing this, when you're pulling all of this stuff out, you're doing so thinking about what are all of the potential issues that I might have to spot on an exam. So there might be the issue in an analysis of purposeful availment. But there also could be an issue dealing with the internet and whether posting something on the internet created minimum contacts, which is something I learned in class. And then there's also that other subset that could potentially come up in a fact pattern of the stream of commerce cases. So I also want to have that prepared. So that way I'm prepared for any issue and I have a rule for any issue that might come up on an exam. I know what the rule for purposeful availment is. I know what the rule will be if the fact pattern deals with something like an advertisement on the internet. And I know what the rule will be if it deals with the sale of a good, which deals with the stream of commerce cases. And of course, you might think of other potential sub-issues that could come up that I just haven't used in this example. Like, for example, if you're dealing with a contract or an insurance policy, maybe you've dealt with that in class, and that could just be another potential issue that you can raise and another rule statement that you could pre-write. And then, of course, I would write the rule statement for the fairness factors, likely listing what those fairness factors are. Then, of course, you might have the issue of general jurisdiction, and then you would define the rule for general jurisdiction, which essentially means that the defendant has such contacts with the jurisdiction or the state to essentially render them at home because those contacts are so continuous and systematic. So now, if I am preparing for my exam, I know that if I have a personal jurisdiction problem, these are all of the potential issues that could come up. And for all of those potential issues, I already have written my rule statement. So now I just want to give a little bit more of a specific example. So this is what it might look like on your page. I've got the issue that could come up under subject matter jurisdiction, which is federal question jurisdiction, and I pre-wrote my rule. A court has federal question jurisdiction over a matter if it arises under the United States Constitution, a treaty, or other federal law. The federal question must be pleaded on the plaintiff's well-pleaded complaint. However, an anticipated defense by a defendant that arises under federal law by itself does not give rise to federal question jurisdiction. So this means that if I have a problem on my exam dealing with federal question jurisdiction, this is the rule I'm either going to one, memorize, or two, I am going to use if I have an open book exam. And it's written in the ways that we've talked about. It's got the general rule, which is just what federal question jurisdiction is. It defines the federal question, indicating that it has to be pleaded on the plaintiff's well-pleaded complaint. And then it gives me an exception. It indicates that an exception to the federal question jurisdiction rule essentially is that if you're using a defendant's defense and as that the defendant is going to raise it, that does not constitute federal question jurisdiction. So similarly, if I am talking about diversity of citizenship jurisdiction, I'm going to indicate what my general rule is. A federal court has diversity of citizenship jurisdiction if the suit is between citizens of different states and the amount in controversy exceeds $75,000. So this is a rule statement in which I have elements. I need two elements to be present in diversity of citizenship jurisdiction. I have diversity and amount in controversy. So how do you then pre-write a rule statement dealing with elements? I've indicated it here, right? Each element should be a subheading. So my first heading, which is in italics on the slide, is diversity of citizenship. And my second subheading is amount in controversy. And underneath those two subheadings, I would write the rule. I would write the rule for diversity of citizenship, which then requires a definition of domicile. And remember, when you're pre-writing, you're thinking about all of the potential issues that can come up on an exam. So I might have a fact pattern dealing with individuals, or I could potentially have a fact pattern dealing with corporations, or an unincorporated association, perhaps a foreign individual, or something else that you've learned in class. So essentially, I want to provide all of the rules for that in a list because I'm pre-writing them out. So that way, if I've had an exam dealing with just individuals, my rule statement for the individuals would already be written out, or a corporation or so forth. And then my second element, which is amount in controversy, I would then insert the rule statement for the amount in controversy, which would have just meant essentially that the amount in controversy needs to be on the complaint and pled in good faith, and it cannot be egregious, right? And then an exception to the amount in controversy requirement could be listed if you had learned one in class. So these are essentially the 3 steps with an example that you would follow if you are pre-writing for your exams. Let's talk quickly about the benefits of doing this. One of the greatest benefits of doing this is issue spotting. It allows you to issue spot with better precision on your final exam. And so why? It's because you have sat down before your final with all of your materials and all of the law that you've learned, and you've effectively spotted all of the potential issues before you look at a fact pattern. So would you write every single thing in your pre-written exam on your exam, which I see as someone's question? No, you wouldn't, right? You would only use the pre-written rules that are applicable to your fact pattern. But the purpose of writing the rules for all potential issues before your exam helps you with issue spotting. It almost serves also as a checklist. You could say, okay, the first thing in my pre-written rule is federal question. Is that present here? No. Let me move to diversity of citizenship jurisdiction. So pre-writing your exams really, really helps with issue spotting. It also helps with organizational planning. One of the biggest issues students have with writing exams is disorganization. It's difficult to follow, there's a lot of moving parts, and the essay answer is really not as organized as it could be, which then in turn likely results in a lower score. So when you pre-plan that organizational structure of your essay, you already then also know that you're going in with headings, and you're going in with even headings for overall issues, but also subtopics and even element subheadings. So it really just strengthens the organization of your essays. Another benefit is rule statement development. Your rule statements can be a lot cleaner, a lot more precise, and overall just a lot better. Mainly because you're not then forcing yourself to just think of rule statements on the fly under pressure in a timed like exam setting. So if you have a closed book exam, you would have memorized the rules that you've already pre-written. So you've already planned what you were going to say, then you're just memorizing it. Again, not trying to write a just disjointed rule from memory. You know all of the different parts of this rule, but because you didn't write it in a cohesive manner, you're just writing it for the first time on the exam. We're eliminating you needing to do that because you've already organized it how you would like to write it on an exam, and then you've memorized it in that way. If you have an open book exam, then the benefit is quite large, especially because you pre-wrote your rule. Now you can just take that rule and write it into ExamSoft or whatever software you use to write your exam. Finally, the last benefit of this really is understanding and memorization. Because you're going through the entire subject and you're going through each topic, it really strengthens your understanding of a topic because you're going through it with a fine-tooth comb, you're organizing it, and you're parsing out and crafting rules for that particular topic. And of course, doing this, you're working with the material. It's also helping you memorize and just know the law better. So now, if you have any questions, please feel free to type them in the Q&A. And I do have a couple, so I'm going to address those. I just addressed one, right? And I'll just repeat what the question was. There was a question that indicated, do you have to just copy and paste your entire pre-written exam, even if the issues aren't applicable, into your exam answer? And the answer is no, right? So you're preparing in advance for issues that are being tested, but of course, not all of those issues are going to be tested. So you're just pre-planning for the issues. So you're just addressing and writing for the issues that are applicable or that are raised by your fact pattern. So for example, in my personal jurisdiction example, I indicated that you could pre-write the rules for all different things under minimum context, an internet case, stream of commerce, or anything else. And so it might be that your facts have absolutely nothing to do with the internet. So then you would not include your pre-written rule for the internet cases, right? So it's a potential issue that could have come up that you prepared for, but it's not going to be one that you end up using on your exam. So another question that I have is, if we're dealing with restatements or we're dealing with statutes, should we copy and paste the restatements or the statutes verbatim? So that's a good question. And I always say, anytime I answer questions that have to do specifically with how you should be writing for a class, the first person you should always ask is your professor. So if your professor wants you to quote, cite, or copy verbatim statutes or restatements, then you should, right? Because you should do what your professor is looking for. However, most of the time, I know that's not the case. And so a lot of times, right, you want to be writing the rule statements in a way that's going to be easier for you to know and easier for you to write down and understand. So sometimes copying language from a dense restatement, that's probably not going to be most effective for you. So I think that if a restatement has 3 elements, right, write those elements in a way that's easier for you to understand. You don't necessarily need to copy a whole statute into your notes, right? What are the relevant parts of a law that you've learned? And also, how can you write that in a way that's easiest for you to understand and to then regurgitate and apply on an exam? So we have one more question, and the question is kind of in 2 parts. So let me read it. So someone is asking, if I'm having an open book exam, how do I prepare for that differently if I'm pre-writing for a closed book exam? So that's for the first part of the question. And then finally, isn't this a little difficult, or is this more difficult to do if we've got a closed book exam? And so my opinion is that you should be preparing for an open book exam or a closed book exam in the same manner. So even if your exam is closed or open book, you should be pre-writing regardless in the steps that we've talked about. There is no differential between if it's open or closed book. The one thing that I will say is that most final exams are still timed. So even though you do have the luxury of having these pre-written rule statements out, you just want to be careful in terms of constantly looking at your notes and then relying on them, and flipping through them, because of course, right, you would want to do that, but maybe timing is on your side, and that maybe eats up some of the time that you're spending when you're writing an exam. So I think that understanding and memorizing is equally as important, and pre-writing and memorizing your pre-written rules is equally as important, even if you have an open book exam. So of course, if you have any other questions, you can always feel free to reach out to us at Law Tutor. We always help students with their final exams, especially if you're looking for a little bit more individual attention and you think you would be interested in one-on-one tutoring and working with one of our tutors to help you prepare for exams. Please don't hesitate to reach out. We definitely have the availability, and we are always here to help law students. And thank you all so much for attending one of our exam sessions for law students. Specifically, we talked today about pre-writing exams, and we hope to see you all in the future. And thank you so much for coming today.